may be seated. Okay, good morning. Welcome to the First District Court of Appeal. We have one case on the docket today. It is James Pugh and Heather Pugh versus Mary Johnson et al. Case number 251070. You may proceed, counsel, when you're ready.
Good morning. My name is Scott Work. I represent the appellants, James and Heather Pugh. I don't know if you had a chance to see, we filed a motion to present some demonstrative aids, and it's not really part of my presentation, but this is a real estate case. It involves a particular set of property that's maybe when I read real estate cases, it's one of the hardest things to figure out is what's going on with the property and the facts. And so we thought that providing these visual aids from the record might benefit in making a decision on this case.
Thanks. Thank you, counsel. We do have those.
Okay, and if you'd like, I can walk through maybe the first one because it's probably the simplest, because it was color-coded by opposing counsel.
I'll defer to you. If you would like to do that, you may, but we also have studied the briefs and the record pretty thoroughly.
Okay. Thank you. If it pleases the court, then I'll start. Okay. Our main contention in this case is that we believe the trial court ruling did not seem to follow a known legal theory. The court did not rule on the usual easement defenses, such as adverse possession, abandonment, or estoppel. In the summary judgment, the trial court did cite to Smith v. Horn and Travis versus Coral Gables, and it generally followed those cases in adjudicating the centerline issues. But neither of those cases mandate the finding by the trial court regarding the implied easement rights. We posited that the court's ruling was most similar to a finding that an easement termination based on physical changes to the land. The appellees disagreed and argued that the court didn't terminate an existing implied easement. Instead, the court interpreted the scope of the easement implied from the plat to be limited to the body of water and not the entire, what we call the platted canal parcel. Specifically, the appellees argued that the trial court interpreted a plus-minus notation that's found on the rear boundaries of the lots abutting the platted canal parcel to mean that the easement area is limited to the shoreline of the existing body of water. We don't believe that the court did interpret the plus-minus notation that way, but if the judge did, we believe that was error. That interpretation would be inconsistent with the trial court's other findings. In the summary judgment, that we believe the trial court correctly found that the boundary line shown on the plat controls over the plus-minus notation for purposes of determining the legal boundaries of the platted lots and for determining the boundaries of the centerline parcels attached to each platted lot. That finding, and I don't believe that finding was raised on appeal by either party. Now, we recognize there's a difference between the application of the centerline rule, which deals with ownership of the property underlying platted roads, bodies of water, parks, canals. Whereas easement applied from the plats deal with use rights in the plat over the same platted roads, water bodies, or canals. However, we don't believe it's logical that the boundaries of the lots are determined by the boundaries shown on the plat, but the easements implied over those same parcels are determined by what is actually located on the ground.
Counsel, so even assuming we agree with you that the plat is fixed, like the easement boundaries are fixed, would you agree that the plat's reference to canal means that the easement's use must have some canal-like purpose?
Yes, and I believe that I believe that the cases mandate that.
Right, and so
Miami versus State of the East Coast Railroad, I believe. Is
right, and so what canal-like purpose do your clients seek to have that they don't already have by virtue of their access to the canal from their own property? So if I analogize the uses that you could put a canal to riparian rights.
Now, as we cited in the Publix cases and the Lauderdale Boatyard cases, a man-made artificial waterway, body of water like this does not carry riparian rights. But that being said, I likened the canal uses to what almost like riparian rights, which includes use of the water to swim, to fish, but we also believe that that would mean use of the shoreline. We're talking about the dry land within the platted canal parcel is the issue is the property at issue here. We believe that canal uses can also mean standing on the side to fish. It can also mean standing on the shore to access the water. And probably most importantly, by putting a canal on the property, I think the primary use of canal is a body of water used to get to another body of water. So as originally platted, we believe the canal was to provide access to the larger body of water, the Choctawhatchee Bay. When the dry land was formed, it cut off the water access to the Choctawhatchee Bay, but it did provide land access to the Choctawhatchee Bay. So we believe there's an ingress and egress function to a canal that's lost by the trial court's ruling.
But is that type of ingress and egress by water, isn't that different in kind than by foot?
Yes.
And
Yes.
Is that a consideration that we actually should have in mind here in terms of the scope of the easement?
I don't believe so, but that's because I likened in the Travis court, likened the canal to an easement for a canal to an easement for a road. We all know when a road gets platted, the platted road is probably, they could be 40 feet wide, they could be 60 feet wide, big highways are 100 feet wide. The paved surface is actually only a small portion of that. The neighborhoods in this plat are a good example. The platted roads are 60 feet wide, which is all the land set aside to put a road in, but the road itself is only about 20 feet wide. But that doesn't mean the rest of the road easement goes away, because you're only using a small portion of it.
Let's imagine the canal was still exactly as it was originally. Your position is that a property owner on the canal could walk on the property of the plot next to it in order to stand and fish in the canal?
No, we don't. It's not our position that you can walk across somebody else's property. It's only our position that you can walk across the property set aside on the plat as the canal, which
Right,
I've deemed a platted canal part, which we've labeled a platted canal parcel.
So tell me how that fits in with your argument about standing from property and fishing into the water.
Well, the platted canal parcel, we're saying, was set aside for canal-related purposes, just like it was a good analogy, at least in my mind, is a common area in a neighborhood. That area was set aside for admittedly for canal-related purposes, but it was set aside for community purposes. So what we're saying is that even though part of it was either never dredged or is now dry, the neighbors can still walk within the dry land in the platted canal parcel for uses similar to what you'd use a body of water for, which includes.
If you don't have, say, a boat or a kayak or something that you're going to paddle out into the main body of water with, I understand your ingress-egress argument from the actual canal surface water. But if you don't have that and you're not going to swim through it, it sounds like your argument, though, is also that you could walk along the edge of it all the way out.
Only if you're walking on the platted canal parcel itself. I don't believe you'd have the right to walk on somebody else's property, somebody else's platted lot, because as you've seen in the plat, the lots end and the platted canal parcels at the end. There's in most places on the lots abutting the canal parcel, there is a small section of land between the rear boundary of the platted lot and where the waterway starts today. Sometimes it's 5 feet, sometimes it's 10 feet. Opposing counsel has said that's the other side's backyard.
Right, so.
But we don't believe that's their backyard.
My question ultimately is walking on that, is walking on that, whether it's for ingress, egress, or to fish, is that really properly considered a canal purpose?
We believe so. Like I said, the best analogy I could find in the law was riparian rights.
Is there anything, so, and I do think you've acknowledged that riparian rights don't technically apply
That's
to a
correct.
man-made body of water.
That's
So
correct.
is there anything in the plat itself, anything textually that we can pull from the plat that would provide those other recreational activities as a right for this particular easement?
I don't believe so.
Okay.
Just out of curiosity, Counselor, on Exhibit B, or I guess it's the second
Yes,
exhibit.
ma'am.
The color one with
Yes, ma'am.
all the hash marks. I'm just curious, out of curiosity, so you have the internal pink line. What is that based on? I'm just curious how y'all
Yes.
determine that, because the original plat, if you zoom in, it says not included, but there's no measurements kind of.
Yeah, it was
saying
done in
how
the late
big that
60s.
was.
Yes,
So
ma'am.
what did
So
you- what's
just
that
to walk you
based
through the
upon?
colored photo here, and I'll show you the survey that this colored photo was superimposed on is also in this package. So that in exhibit, it says Exhibit B. We labeled it Exhibit 1. It was Exhibit B to the pleading that in the record. But the blue area is the body of water that exists there today. The pink lines that you see that are kind of horseshoe shaped, those roughly follow the boundaries of the surveyed boundaries of the platted canal parcel. We had our surveyor go out and plat the boundaries of the platted canal parcel on the land as it exists today. So the pink lines are the platted canal parcel. The blue is the waterway. The hatched marks on the right side on the top, that's the North Beach area. That's the property at issue today, the easement rights over the North Beach area. It's kind of, part of it's green, part of it's yellow in the top right-hand corner, but that's the hatch marks. That's the area in dispute. And as you can see, it's located within the platted canal parcel, and as the survey shows, it's dry land. Exhibit 2, which is labeled on the document Exhibit C, you can see this one is just simply the platted, this is the same survey that the colored drawing was created from, but it just simply shows the platted canal parcel highlighted in yellow. So you can see it superimposed on what's actually there today with the body of water, with the small island parcel in the center.
I got a question for you.
Yes, sir.
So is your position do you think you could hire a dredging company to come out and clear this portion and reopen it and reconnect it to the main body of water?
That'd be a DEP question, and
Well,
it seems like that would be a difficult ask from the DEP, from what I understand. But theoretically, if the easement rights are found to remain, then theoretically, yes, that could happen, subject to, I think, some pretty
Sure, the
daunting
regulatory
regulatory approvals. Yes, sir. Thank you.
Thank you. The remainder of your time will be reserved for your rebuttal.
Okay, thank you.
May it please the court, my name is Robert Powell, and I represent the Appleys, James and Mary Johnson, and Jeannie Martin as trustee of the Martin Trust. This court should affirm the trial court. The trial court correctly applied the centerline rule and limited the Pew's implied easement to only the submerged portion of the platted canal parcel. This is the only result that's consistent with Florida law and would avoid disturbing 100-year-old Florida Supreme Court precedent and would actually require this court to enunciate a new rule of Florida real property jurisprudence that the beneficiary of an implied easement over a waterway accrues pedestrian access rights whenever the waterway recedes. You see that nowhere in Florida jurisprudence, and this is not the case to adopt that rule today.
Well, let me ask a question about expectation. So as I'm looking at the plat, to me, the bay access, I'm losing, if I'm one of these landowners, I've lost bay access, which is valuable. And so the promise to me of having bay access, and now it's been extinguished because of the accretion of the sand, why wouldn't it be reasonable that a developer would think that as long as that is a limited use for bay access, not other recreational, not an expansion of that, why wouldn't that be reasonable for a developer to have as intended for this easement?
I think if the corporate developer in this case, when the subdivision was platted in 1967, intended that result, then that could have been easily accomplished with additional language in the plat. It's simply not there. It was an entirely submerged, horseshoe-shaped canal parcel that opened to the Choctawhatchee Bay on both sides. And I think, Judge Ray, your question to the Appellant's Counsel about the distinctions between water use and pedestrian use resonate in this setting. They're fundamentally different. There's a fundamentally different type of intrusion that happens to a residential owner. When you're looking out your back porch and in the distance you see someone over water that's fishing or is on a paddleboard, as opposed to an individual who's literally walking through your backyard. We heard a couple of times, we're not looking to cross anybody's private property. Well, no, that's exactly what you're attempting to do if we agree that the trial court correctly applied the centerline rule. And neither of the parties have challenged the trial court's ruling in that regard. That was a correct application because there's no intent in the plat or the initial granting instruments to withhold title to the center of the platted canal parcel in those conveyances. So the Smith v. Horn rule from 1915's Florida Supreme Court case was correctly applied, but there are two other rules in that opinion that also deserve airtime in this setting. First is the dedication of the easement, that when you plat a subdivision and you convey lots referencing a plat that depicts a road or a street or a waterway, like in this case, you dedicate an implied easement to the purchasers of those lots to use the street or roadway. But the last, which is the Travis versus City of Coral Gables application to a canal, is the vacation of the easement. What we're trying to do is fit the circumstances of natural fluctuation of a waterway into the framework of the Florida Supreme Court precedent that applied to a road. In 1915, the Florida Supreme Court was observing that the town of Daytona Beach issued an ordinance vacating Cemetery Street, which was on the Memento Plat. And they said that if the right-of-way is lawfully surrendered, that was the verbiage that was used, lawfully surrendered, then the implied easement goes away. Applying that framework to a waterway, the trial court correctly reasoned that when a waterway recedes, the underlying fee, which extends to the center of the platted canal parcel, is relieved of the easement. And that's consistent with the developer's intent as gleaned from the plat.
So it seems like everybody agrees that riparian and littoral rights aren't at play here, right?
Yes, Your Honor.
So it seems like that is imposing a property law concept from riparian rights about accretion and erosion for the growth, for a piece of property to either grow or shrink as a result of natural fluctuations of the body of water. It seems to me that your argument is imposing that legal framework onto this circumstance where we all agree it doesn't apply. So tell me how that's wrong.
No, I have to disaggregate the riparian rights concept from the center line and implied easement concepts, Your Honor. First, it bears mention that the Johnson's lot, Lot 30, is contiguous to the Choctawhatchee Bay. That's navigable water. They have riparian rights. And if they have riparian rights, that means the accretion that created the North Beach is their private property. With respect to Ms. Martin, who's Lot 29, right next door, the accreted area that, again, started with the Johnson's bayfront lot is all within the boundary of her lot as extended to the center of the platted canal parcel. Why is that important? Because of the concession we just heard. We're not trying to go across anyone's backyard or private property. Yes, that's exactly what you're attempting to do. And you're transforming your rights under this plat. You're attempting to essentially rewrite what the plat states in accruing a right of ingress and egress, pedestrian rights to basically go hang out. to congregate on the North Beach, which they were attempting to do when they acquired the quitclaim deed from Ricky White, who was an heir of the developer's principal. That was their initial position in the lawsuit. We own this. We just got the quitclaim deed. And a companion case, the Stanek case, which is the final judgments, I believe it's 60-61 of the record, invalidated that easement, and then the Pews pivoted to this idea of an implied easement. Well, the implied easement, as we know from Easton versus Appler, the third DCA case from 1989, the extent of an easement implied from a plat depends on the intention of the parties. That intent is determined by the language of the granting instrument, the situation of the properties, and the surrounding circumstances. And as this court acknowledged in 1984 in Walters v. McCall, it is imperative to contextualize any easement based on the circumstances that existed when it was created.
Well, the circumstances that existed when it created allowed for the lot owners to have access to the bay, right?
Yes, sir.
And I mean, it seems like it's fair that's what the plat suggested, is that they would have access to the bay in two places for, at the very least, for ingress and egress. Do you disagree that that's not a part of the canal purpose that we could attribute to this?
I agree that there was an intent to provide water access to the bay, but not pedestrian access. It's fundamentally different. By the way, it is more than footnote worthy that the Pews acquired their lot, I believe in 2017, when this canal had already been filled in the manner that it was. So it's a little disingenuous to contend that, well, we bought this lot anticipating that we were going to have water access to the bay, when that was not the configuration of the property. As it's situated today, as the court is aware, that the canal parcel is only partially submerged.
Let me ask you a question that Judge Long asked of your opposing counsel. Setting aside permitting requirements, could the easement holders dredge the area to return it to its original use, that is, original water use, so that they could have the access to the bay like it was when it was originally platted?
Yes, Your Honor, perhaps. I think that would be a much closer case, but that's not a remedy that's ever been framed by the pleadings in nearly half-decade-long litigation. And I would also agree with Judge Long and opposing counsel that that would be a tall order to get regulatory approval to do that. But conceptually, that's not necessarily inconsistent with the case law. It's just something that's not been sought in this particular case.
But isn't walking across to the bay a much less significant intrusion on the property than bringing a dredge out and tearing it out?
Perhaps, but actually the latter would restore the waterway, and so you wouldn't have any individual on pedestrian walking back and forth. And I would respectfully disagree. I believe that there's a fundamental type of intrusion that occurs when you see somebody walking through your backyard. That's what they're advocating. Had the corporate developer intended that, it would have been very easy to carve out the lower 5 or 10 feet and designating it as a path, a trail, a walkway. Any of those types of words would have supported this type of use.
Well, why would they do that when there was a canal there?
Well, that's perhaps
I mean, would that be a reasonable thing for them to do, for us to expect them to do when there's a current canal that's dredged?
No, I think it just illustrates the point that the developer here had a specific intent, and you're right, it was fully submerged, so that it would have been asinine to say, we're going to put a path here when there's a walkway. Nobody would have bought lots if you could just walk, see people walking through your backyards.
But isn't that the point? That nobody would have bought the lots if they weren't going to have access to the bay in the way that it's currently constructed on the plat when it's originally set?
Perhaps, but this is not a lot purchaser from 1967, or even 1971, or even 1991. This is a much more recent purchaser of lots that was fully aware.
The new purchaser still gets the benefit of the scope of the property and easement rights as they exist when they buy the property, right? They don't have to have participated in the original platting process.
That's probably correct, Your Honor, but I think what also deserves some consideration is the plus-minus denotations. I haven't gotten to that yet. It's in the plat, and it's only on the lots that abut the water. The plus-minus denotations underscore, and we had a surveying expert, Mr. Eric Stewart, whose affidavit is at page 436 of the record. Mr. Stewart's affidavit discusses the significance of the plus-minus denotations, that the developer contemplated that these lots that are next to a waterway could fluctuate over time with the natural fluctuations, the tidal influences being adjacent to the Choctawhatchee Bay. So it is fairly inferable, consistent with that the developer also contemplated that this various scenario would occur, that over time, having dredged the original waterway in an artificial manner, that it would fill in. And no measures were taken to assure for this particular situation that, regardless of any fluctuation in the waterway, this is a park, it's a green space, it's an open way, and all of the canal abutting owners get that right, regardless of whether it's submerged or upland. Had the developer intended to convey that purpose, that could have easily been accomplished, but it's just simply not there. It's not on the
Counsel,
plan.
with respect to the plus-minus markings, in the briefing, appellants point, they cite to some administrative rules and state that as a matter of law, these are just imprecise measurement tolerances. What role, if any, does that administrative rule play in this case?
Yes, Your Honor. It doesn't apply. I believe it's 5J-710 of the Florida Administrative Code. It came into existence in 2010. And this platted subdivision was created in November of 1967. So the notion that rule that came into existence 43 years later applies in this setting is completely specious.
Why would we say it's more reasonable to think that the plus and minus means that they're thinking maybe in 50 years DEP won't allow redredging and it's going to fill in and you're no longer going to have access, rather than just saying the plus or minus might be attributed to the tide fluctuations that ordinarily occur, and so it might change a little bit from time to time?
It's probably a fair statement that the developer was not contemplating the difficulty of navigating administrative approval to dredge when this plat was recorded in 1967. I don't even know what the politics were like, but it doesn't matter. I can't imagine that was on the corporate developer's mind. But again, the circumstances that applied at the time of creation of this easement.
But we did have tides, right? In the 60s, right? The tides still went up and went down, and there was natural fluctuations from day to day, and even within the days of
Yes, Your Honor.
the water is a little bit higher sometimes and a little bit lower sometimes, and so it's not uncommon to have a plus or minus tolerance to deal with that kind of naturally occurring adjustment in the body of water.
I think that's right. I don't believe that that's a dispositive matter, and that's something that warrants reversal of the trial court's ruling. Again, the pleadings over half a decade have never framed the idea of let's redredge this. That's a remedy that we're seeking. We're seeking injunctive relief against all these canal fronting owners. In fact, there'd probably be indispensable parties who are the other lot owners that are not a party to this action that would be necessary in order to effectuate that type of relief. So there's certainly, their property rights are implicated by that. I keep coming back to Easton versus Appler. That's a case that the appellants rely on extensively, but if you unpack it, along with most of the other authority that's in the appellant's brief, you find that it's readily distinguishable factually, and actually the sound bites support the appellee's position. The extent of an easement implied by a plat is determined by the intention of the parties, and that's determined by the intent comes from the language of the granting instrument, the situation of the properties, and the surrounding circumstances. It is undisputed in the summary judgment record below that this was an entirely submerged canal as of the late 1960s when this plat was created, when this subdivision was created. So the idea for a corporate developer to plat a subdivision granting an implied easement over waterway would intend for those lot purchasers to later have pedestrian rights of ingress and egress, and then have the ability to congregate on any resulting shoreline that comes from accretion, it strains credulity at best. It's just simply not something that would have been in the contemplation of a residential subdivision developer. And if that were the case, it could have easily been accomplished by adding additional language to the plat. Here's the intent. Or we're going to enjoin these lots, or we're going to record a covenant that requires this canal to be redredged every 10 years, subject to permitting. Things of that nature. There's a myriad of other things that could have been done if the goal and intent was to sell lots to these individuals and say, yeah, you can, if there's accretion, if this fills in, just get over here however you can. Whether there's water up at the end of your lot, you can hop on your paddleboard and come over to the accreted area, or if you just need to walk on foot, come on over and hang out on the new shoreline that we'll call Lake Lorraine Park. It's nowhere in the plat.
Well, counsel, if the canal were to dry up entirely, is it your position the easement would be permanently extinguished?
Yes. Yes, and in the same manner as any lawful surrender, as the Florida Supreme Court held in Smith v. Horn, any lawful surrender of a right-of-way will result in the easement being extinguished. The difficulty in this case, admittedly, is putting the framework of a natural right-of-way, like a waterway, into the context of a road or a street where you have human action, you have governmental action. So it's very clear what the intent was. The town of Daytona Beach, it issues an ordinance vacating the street on the Memento plat. Well, it was clear that resulted in the extinguishment of the easement. Here it just happens to be a natural waterway, natural tidal forces and fluctuations over time that gave rise to uplands and dry land.
That certainly changes kind of the bundle of rights that each property owner has. I mean, for those landowners, it greatly expands their property rights to the detriment of the adjoining landowners that used to have access via waterway to that portion of their property. And is that something that the developer, you think, could have contemplated? That type of dramatic expansion and reduction in your bundle of property rights?
I do believe it was contemplated. The plus-minus denotations, I think, underscore that. We also have to distinguish bayfront lots, which are adjacent to navigable water that enjoy riparian rights, from the canal fronting lots that do not. The Johnson's lot is on the Choctawhatchee Bay. They have riparian rights. They have the rights to accretion. So the North Beach area that's resulted in, over time, in that North Beach area adjacent to their property is their private property. That's what they bargained for. Canal lot owners, on the other hand, did not bargain for riparian rights as a matter of Florida law. And so when we're balancing the equities, when we're talking about windfalls or detriments, the tremendous windfall would be to allow pedestrian access to these interior canal fronting lot owners where there's no longer water in the canal parcel in that area. So I see I've got about a minute left. I'd like to very briefly touch on, there's just a couple of Florida Supreme Court cases that I believe support our position, that there are cherry-picked sound bites that seem to superficially support the appellant's position, but when you carefully unpack the very factually nuanced opinions, they do not. First is McCorkadale versus Keaton, a 1953 Florida Supreme Court case. Sunnyside Park was designated on the plat, a Gulfront plat, for use of the lot purchasers. The developer put a 10 by 12 concession stand and was ultimately enjoined to remove it because that interfered with the expectations of those lot purchasers. So it all comes back to this idea of estoppel. What did the grantor or the developer represent in the plat that the developer could be stopped from denying lot purchasers the right to use? The language of the plat, the circumstances of the properties, the situation of everything. Your Honors, I see my time has concluded. This court should affirm the trial court, and I'm happy to answer any other questions or concerns that the court may have.
Thank you. Thank you, counsel.
Thank you, Ron.
I'll be very brief. I did want to correct a couple of things by opposing counsel. and make a few comments based on his statements. One thing opposing counsel said stood out to me because I don't believe it's factually correct. He said that the facts of the case show that it's undisputed that the entire canal was originally dredged by the developer. And that's simply not true. I don't believe that I'm not sure if there's any evidence in the record that the entire canal was actually dredged by the developer. It was disputed by the parties. The parties didn't dispute that the North Beach area, the property in dispute now, was actually dredged. There are photos in the records that show, aerial photos that show that part actually dredged. There were no such photos that showed that the South Beach area was actually dredged, but there was testimony there's testimony in the record by a witness that said that he saw that the South Beach area was open to Choctawhatchee Bay at one point. But I'm not aware of any evidence in the record that says that the whole Platted Canal parcel was actually dredged at one point. The aerial photos I've seen, my personal belief in the aerial photos I've seen is that it was only it was probably half of it. But again, I don't believe I think I would disagree that it's no facts, that it's undisputed that the whole thing was dredged. I don't believe that the whole thing was ever dredged. Opposing counsel went into a lot of detail to say that we're trying to get rights to walk across people's backyards. Again, what we're saying is that the owners in the plat would have the right to walk within the platted canal parcel via the easement that the platted canal parcel the implied easement that's created by the representation of the platted canal parcel on the plat. We're not suggesting that anybody have the right to walk through anybody's platted lots, only on the easement area that's represented by the platted canal parcel on the plat. Opposing counsel actually corrected me, and I agree with him, that the centerline rule applied by the trial court found that the owners of the lots abutting the Platted Canal parcel all own to the center of the Platted Canal parcel. And that's true. They have fee title to that. However, the Platted Canal parcel represents an easement sitting over the title to those properties, and that's the area. And so it's those easement rights that we're suggesting that all the owners in the plat have the right to use over the Platted Canal parcel, notwithstanding who owns the underlying fee. I believe we've cited the case to Wilson v. Dunlap, directly on point, that says that when you, it doesn't matter who owns the underlying fee, that you take subject to any easements implied from the plat when the title to the underlying fee changes hands. And then the last thing I wanted to mention was opposing counsel said that they believe that the trial court found, they believe that it's correct that the trial court found that the receding of the water going away, the land becoming dry, is similar to the lawful surrender of a right-of-way. And that seems like a strange and an illogical stretch to me to make, because we all know what's required to do a lawful surrender of a right-of-way. It usually requires the local government. It requires the city council. It requires the county. It requires them to come in and actually vacate a right-of-way. So that's a separate legal process. I believe it's spelled out in Chapter 177 of Florida statutes. Don't quote me on that, but that's a legal process. And to equate that to some dry land forming or water receding from private property seems like a stretch to me. And again, we're asking for the court to overturn, and I'll be happy to answer any questions if there's any more.
Thank you. Thank you to both counsel. If there is nothing else, the court stands adjourned.